Yes, friends. So we are taking up today employees compensation insurance. Someone has already raised the hands. Who is this gentleman? Maybe by mistake just close it. So employees compensation insurance is the product of the day. Let's understand what this product is. Because this is not a new policy, everybody must be knowing about this policy. Only thing is, whether or not you have started selling this policy, this is only a matter of concern. Otherwise, product is pretty old and this is already available with all the general insurance companies. The nitty-gritties of this product have to be understood by all of you because this is a little bit different from the other policies. So presentation is visible to all of you. Anybody can confirm if it is visible to all of you. Good. Okay, see, this is by virtue of an act. That act is called Employees Compensation Act 1923. Earlier it was Workmen's Compensation Act 1923. So this workman compensation policy is in compliance to this act because this act came before independence in 1923. That time the British government was there, they framed it, they implemented it, and this was the provision made in this act that if during the working hours any employee, worker or labor is suffering, he should be provided with the financial protection. So this act basically is known as the Social Security legislation. Social Security legislation. Why? Because it aims to provide financial protection to workmen and their dependents in case of accidental injury by means of payment of compensation by the employers. That means this is the responsibility of every employer to provide the compensation to their workmen or employees or labor if they are suffering from any accidental injury during the working hours. It may be an injury, a disability, or a death. If it is a death, in that case the compensation has to be paid to the dependent of the workman. Or in case of injury or disability, the compensation will go to the workman himself. So how the compensation can be paid? In the form of finance only, financial compensation only. Means the body part cannot be recovered, the body cannot be recovered in case of death. So only the financial protection is provided. That is the reason this act is known as the Social Security legislation. Now, since this is a pretty old act, this came into force before independence. So there are two major changes in this act. First of all, it is no longer called as the Workman Compensation Act or Workman Compensation Policy. It has been replaced as Employees Compensation Act 1923 and in compliance thereto the policy known as the Employees Compensation Insurance. Secondly, there are amendments from time to time in the wage limit. Earlier it was in hundreds, then it was raised to 4,000 rupees, then to 8,000 rupees, and recently in 2020 it has been raised to 15,000 rupees per month. So the compensation amount is arrived at by applying the age and the wages, and as per the recent development the wage level is increased to a limit of 15,000 rupees per month. So whenever an employee meets with an accident which led to fatal, or the employer is liable to pay the compensation. Employer could be a shopkeeper, a factory owner, an office, or a company, or even a contractor, or a builder. Whoever is the employer, this is his responsibility to pay the compensation. Why? Because there is a statutory requirement. What is the statutory requirement? As per section 17, the employee has a right to recover compensation from the contractor or employer in case of in case of injury, disability, or death during the working hours. So if there is a contractor, the responsibility to pay the compensation is of the contractor, not of the principal. Because this is a legal provision as per the Employees Compensation Act, so the employee has got this right to recover the compensation from the employers. So don't get confused over the names. Because the name of the act has been changed as Employees Compensation Act 1923, and similarly the name of policy has been changed as Workman Compensation Insurance is now no longer Workman Compensation Insurance, it has become Employees Compensation Insurance. Even if somebody is asking, the WC policy is there, don't get confused, it means he is asking for the Employees Compensation Insurance. Both are the same things. Now, Employees Compensation Act 1923 says that in case the workman has suffered any death or disability due to accident arising out of and in the course of employment, in that case provide relief, financial relief to the workman or their dependents. There could be various circumstances because of that this situation may arise. For example, there is personal negligence of the employer, personal negligence of the employee, personal negligence of the fellow employees, breach of statutory regulations, for example, Factories Act, or failure to provide safe place of work by the employer. So these are the situations where the circumstances may create such a situation where the employee or the workman or the laborer has suffered injury, disability, or death. So in that case, it will become the responsibility of the employer to pay the compensation. Now this is important to understand that the accident should happen during the course of employment. Any event which is neither expected nor designed is called accident. That means this is a sudden event, untoward, unexpected, unplanned. That is called accident. But the important thing is in the course of employment, means during the working hours. It indicates the time when the injury is caused. If it is on the holiday, if the employee is on the leave for a few days, and then he suffered injury, this is not the responsibility of the employer to pay the compensation. But if he is working during working hours, during duty hours, if anything has happened to him, this is the responsibility of the employer to pay the compensation. So in the course of employment is something which is covered, but out of employment is not covered. Out of employment refers and establishes the cause connection between the injury and the employment. So if it is out of employment, there is no responsibility of the employer. So ultimately, what is the responsibility of the employer? what he has to pay and when he has to pay and how much he has to pay. So the Act provides that the employer has to compensate the employee who has suffered an accident arising out of and in the course of employment, resulting into following circumstances. What they are? If the workman has suffered death, or permanent total disablement, or permanent partial disablement, or temporary total disablement, or temporary partial disablement, or maybe an occupational disease. So these are within the coverage of the Employees Compensation Act. And under all these circumstances, the employer is responsible to pay the compensation. Employee or the worker or the workman may suffer any of these injuries or death or disabilities. Now the question is, suppose the workman has suffered death due to accident during the working hours. What will happen? Employer has to pay the compensation. So why he should pay the compensation from his own pocket? What he will prefer, he will take a policy and the liability will be transferred to the insurance company. And taking a policy for the workman's safety is always required because this is statutory liability, because the compensation can be paid in lakhs and millions of rupees. So who will bear this kind of responsibility? It is always better to take an insurance policy. So this liability of huge amount is transferred upon the insurers. This is called the risk management. Now the important thing is how to take this policy. When you are selling this policy, the buyer may ask two things to you. Sir, how the premium will be calculated? And secondly, if anything happened to my workman, how the compensation will be paid? Both the questions are important. And this entire policy is based upon the answer of these two questions. How the premium of the policy will be calculated, and secondly, how the amount of compensation will be calculated if anything happened to the workman or labor of the employees. So the method of calculating the premium is different to other policies. Because here when you are calculating the premium of a workman compensation insurance or employee compensation insurance policy, you need minimum 4 things. Minimum. And all the 4 things are must. Even if single one is missing, you cannot calculate the premium. What these 4 things are? Number of employees. How many workers are there? Salary of these employees per month. What the employer is paying per the month. Even the worker is on the daily wages basis. But what is the monthly income? If you are multiplying with the 30 or 31 days. Period of insurance. Policy could be for a shorter period or for 1 year. But not more than 1 year. After 1 year it has to be renewed. And the 4th one is nature of work. The premium rate would be applicable according to the nature of work. And for that purpose there is a tariff. And tariff, the rates are applied according to the nature of work. That is the basis. Though the tariffs have been dismantled, but the basis is same. So all these 4 information are required to calculate the premium. Otherwise the premium cannot be calculated. Suppose the proposer is not ready to provide you the exact number of employees. You cannot calculate the premium. And that's in that case you have to drop the idea to give the policy. So all the 4 things are required. Then only the premium will be calculated. And suppose if the proposer has given you all the 4 informations, how would you calculate the premium? What you have to do? You have to see the number of employees is multiplied with the salary of the employees per month, multiplied with the period of insurance, number of months. So the multiplication of these 3 things would be the subject matter on which the Premium rate would be applicable according to the nature of work. So the rating depends on nature of work. This is a simple method. Number of employees into salary of these employees per month into period of insurance, number of months, and the rating depends on the nature of work. So, suppose the nature of work is typical one. What will you have to do? You have to take the premium from tariff, the premium rate from the tariff, according to the nature of work. So, for example, I have a farmhouse. And my farmhouse, 20 workers are there. They are engaged in farming, agriculture. Now, I know if anything happens to them during the working hours, it is my responsibility to pay the compensation according to the provisions of the Employees Compensation Act, and that liability would be very heavy upon me. I have no escape. I have to pay because in that case there would be an order of Workmen Compensation Code, Employees Compensation Code. A commissioner can issue the summons in my name. So I will always prefer to take an insurance policy from the insurance company so that the liability is covered, and if anything happens to my 20 of the workers or any of the 20 workers, the insurance company will pay the compensation. So I asked you, I want the employees compensation insurance policy for these workers. You asked me the 4 things. How many workers are there? I said 20. What are you paying? 10,000 rupees to each one. For how much period you want the insurance? For complete 1 year. What is their nature of work? They are engaged in farming. So I have got the information, you have got the information of all the 4 questions. Now you have to calculate the premium. Simple thing. Now you have seen the nature of work is farming. You have seen your tariff. This is the tariff. Rate per milli means per thousand. You have seen the agriculture farms. Rate applicable is 5.85 per thousand. You have taken the rate. And you have applied it on the sum worked out of multiplication of all these first 3 things. And then according to nature of work, the rate is applied. So this is one example. Another example. Suppose I have a big factory. In my factory around 200 workers are there. Say around 150 are unskilled workers and 50 are skilled workers. I know anything can happen to them during the working hours due to accident. In that case, I would be liable to pay the compensation in millions of rupees, so I will better prefer to take an insurance policy. If I am taking the policy for my factory workers, I will provide you the 3 information: number of workers, salary of these workers, period of insurance, and nature of work. So what is the nature of work? Suppose that aerated water manufacturing factory is there. Here 200 workers are there. I have given you the number of workers, 150 unskilled, 50 skilled. Salary for unskilled 10,000 rupees per month, for skilled 15,000 rupees per month. Policy is required for 1 year. Now you have taken the rate of 15.10 per thousand. You have applied this on this sum. Your premium rate is there. And there could be a typical stance where the nature of work is very dangerous. Within no time, the workman can die. The employee can die. In such a critical situation, obviously the premium rate would be very high. But the policy is required. Why? Because the risk is very high. Say for example, I'm running a aero club where I am giving the training to the pilots. Once they are trained, they are hired as pilots. So suppose I have recruited a batch of 50 youngsters. They are learning the flying of aeroplane or helicopter or any air device. Now the question is, I know at any point of time with a minor mistake, any of them can die. And this is a batch of 20 persons. For them right now, for 6 months, I am paying the 50,000 rupees per month. Within 6 months, they will be trained and they will be pilots. They will become the person of millions of rupees. But whatever has to happen, that may happen now, because this is the learning time. Once they have learned, they are expert in their trades. Unfortunate event can be there. So I want the coverage for them. Now if I need a policy, what you will see? You will refer to your tariff. Pilots and employees who may at any time fly. So the rate is 121.60 per million. The rate is very high because the risk is very high. This is the basic funda of the insurance. Lower is the risk, lower is the premium. Higher is the risk, higher is the premium rate. So here in this case, the rate of premium would be applicable 121.60 and this would be applicable on this sum which is coming out of these multiplication of all these things. On that sum, the rate of 121.60 will be applied because this is the nature of work and this is very risky, hazardous. So this is the way how the premium is calculated. This is different to other policies. This is typical way that unless the four informations are there, premium cannot be calculated. Simple thing, part one, this is. But when you are calculating the premium, there could be an additional thing. An additional thing is, there are certain add-on covers available. And these add-on covers are as per the choice of the customer. If you want, you can take. So for example, first one is very important, that is medical expenses. Now the medical expenses table is given where the customer or the proposer can select the limit for his workers or employees according to his choice. Because the limit starts from the 5,000 rupees till 5 lakh rupees or the actual amount of expenses of medical. Premium increases according to the higher limits. And this is advisable to sell this add-on cover while you are selling the employees' compensation insurance policy. Because these medical expenses are not covered under the basic coverage. I have shown you what is covered in the basic coverage. What is the coverage? Only these 5 things. Death, permanent total disablement, permanent partial disablement, temporary disablement by the total or partial, and the occupational disease. Occupational disease is again an option. Some insurers are providing in the inbuilt coverage, some are providing as an add-on cover. So with us, this is an add-on cover. So now, the medical expenses can be selected by the proposer. Suppose he is selecting only 1 lakh rupees per person, per workman. You have to pay 40% of the premium, subject to minimum 100 rupees per person. So this is one criteria whether the good amount of premium can be obtained. If you are giving to a factory or to a company or to a association where the number of workers or employees are in good number, so this premium could be higher than the basic premium. Say suppose the employer has selected the medical limit of 5 lakh rupees per worker. The premium rate would be 125% of the actual premium rate, or minimum 650 rupees per person. If the employer prefers that whatever medical expenses are incurred on my workman, those all expenses should be reimbursed by the insurance company without opting any limit. In that case, he has to pay 150% of the premium. That is minimum 700 rupees per person. Actual expenses will be reimbursed. This is one good add-on which should be sold and advised by you to all the customers who are taking this policy. Now, extension for compensation for occupational disease. I told you in some of the companies this is an inbuilt coverage. Others are charging their extra premium for it as an add-on cover. And the additional premium is 50% of the rate. Though the employer is liable under Employees Compensation Act to pay compensation for occupational disease, the company does not undertake to indemnify the insured for this liability for these diseases. However, this liability can be covered at an additional premium. So this will be covered as add-on cover. How the occupational disease could be there? It depends upon the nature of work or the workman. Because some workers are engaged in the same kind of work since years together. Say suppose a welder is working welding work since last 12 years. So welding is one work where the direct impact is there on the eyes. He may lose eyesight. If one worker is engaged in heavy machineries who are making heavy noise at the time of running, the worker may lose his hearing capacity. Some may suffer skin diseases, hearing impairment, lung cancer, infections due to contamination, infrared radiations. How these diseases came? Just because of the nature of work. Whatever nature of work they are doing, these hazards are attached to that particular profession, particular work. If they are not doing it, they may not suffer it. Suppose a worker is working on the furnace. Now he is inhaling smoke every time. So that smoke is going inside his body, he may suffer the lung infection. So due to occupation, there could be some sickness or disease, and that is covered in our policy on additional premium. If this extension is taken, extension of compensation for occupational disease. One more extension is there, and that is called insured liability for contractors or subcontractors employees. If I am a contractor, I am running 2 projects. On my second project, my subcontractor is there, he is taking care. In my project, 40 workers are there, in his project, 20 workers are there. Now I want the insurance coverage wherein both these projects are covered and total number of workers, my workmen are covered. I can take a policy, no issue. Both the locations will be covered, both the workers who are engaged at both sites can be covered. Only thing is, the subcontractor has to provide the exact and accurate detail of the number of workers as well as the wages paid to them. If he is in a position to submit the wage register or the roll call register, where from it can be checked that the muster is showing number of workers is correct, wage is correct, this endorsement can be given, this add-on cover can be given. Because these are the part of calculation of premium, so there cannot be any negligence, there cannot be any wrong information. If there is any wrong information, it means contractor is hiding something. In that case, the purpose of taking the policy is defeated. Because at the time of claim, the ball is in the court of the insurance company. They will find that the contractor has given the wrong information. On that basis, only the policy can be cancelled. Claim can be rejected. So it is the bounden duty of the contractor to provide the correct information at the time of taking the policy. Now, the second question is, how to pay the compensation in case of anything happening to the workman. So here again, you need three things. You not insurance company, because the insurance company will settle the claim. So to settle the claim, three things are required. First, nature of injury, second, monthly wages, and third is a relevant factor. Now, with nature of injury means what the workman has suffered during the working hours due to accident. This is disability, or this is death, or this is scratches on the body, what it is. Secondly, monthly wages. What wages he is getting. Third is the relevant factor. This relevant factor is important because this is provided in the Employees Compensation Act 1923 as well as in the Employees Compensation Insurance Tariff. Schedule 4 for working out the lump sum amount of compensation provides a table of relevant factor wherein the factor is given according to the age and wages of the worker. The important thing is there is no distinction between an adult and a minor worker with respect to the amount of compensation. That means even if there is a workman who is less than 18 years of age, if he died or he suffered any disability during the working hours, employer cannot deny the compensation. The legal question is, you cannot hire a person who is less than 18 years of age, but that much of awareness has come now. At that time when this act was framed, it was not there. And still, the people are hiring the workmen or employees who are 18 years, less than 18 years of age. So they are responsible to pay the compensation. But there could be a separate legal action against them. Why they have violated the law? There is a factory law. There are other laws who do not permit to hire or to engage a person who is less than 18 years of age. This is the relevant factor table. This is based on the age as well as wages. The example taken is here is salary amount for compensation is say 15,000 rupees per month. Now if the person of say 32 years died, this is what I told you. So for the 32 years age of person who was earning 15,000 rupees per month, the relevant factor is 203.85. And the compensation payable to him is 15,28,875. Now in case of death of a worker, if this is the wages and this is the age, this amount of compensation cannot be changed by insurance company, by employer, or by even the Commissioner of Workmen Compensation Court. Same amount has to be paid. There cannot be any change. Here one important thing is, if the person is less than 18 years of age, say suppose 16 or 17, the factor is highest, 228.54. The amount of compensation is highest, 17,14,050. The way age is increasing, the compensation is going downward. So suppose the person of 65 years has suffered death. The amount of compensation payable is only 7,45,275. And even if the person is more than 65, say 70 or 71, the same fund of 65 years could be applied. Here again, if the worker is less than 16 years of age, say 15 years, 14 years, the same fund of this one will apply. So this relevant factor table is very important to decide the compensation, because relevant factor has to be taken from this table. Simultaneously, the amount of wages is also fixed, that is 50,000. The amount of compensation is also fixed, that has to be picked up as it is. But this is applicable to death only. In case of permanent total disablement, what would happen? This is for permanent total disablement. Now, permanent total disablement means the amount of compensation would be higher as compared to death. Why so? In case of death, the person is no more. Once you are paying the compensation, that would go to his dependents for their survival. But in case of permanent total disability, the workman is still alive, he may not be able to do any work because he is totally disabled permanently. So for his survival also the money is required, for his entire family also the money is required. Obviously here the amount of compensation would be higher. Say at the same age of 16, with the same wages of 15,000 rupees per month, here the compensation is 20,56,860 as against the 17,14,050 in case of death. And as per the Employees Compensation Act, there cannot be any compensation more than this 20,56,860. This is the highest compensation in case of permanent total disability of a workman. Same fund is applicable here. Age and wages, lowest and highest. Less than the lowest means for 14 years, 15 years, same factor. Higher than the 50, 65 years or 70 years, same relevant factor. So this relevant factor table is important to decide the compensation. But there is a lowest limit also. As per the Employees Compensation Act 1923, in case of death resulting from any injury, the amount of compensation shall be equal to 50% of the monthly wages of the deceased workman multiplied by the relevant factor. But under no circumstances it could be less than 1,20,000. If it is more, that more one will be payable. So the formula in case of death is 50% of the monthly wages of the deceased worker. This is applicable to death. For permanent total disablement, the percentage will be little higher. In case of permanent total disablement resulting from the injury, the amount of compensation shall be 60% of the monthly wages of the injured workman, multiplied with the relevant factor. Here again, the minimum compensation limit is 1,40,000. And if by formula the compensation amount is higher than 1,40,000, that higher one would be paid to the workman. So permanent total disability means when the workman is completely disabled for the rest of his life due to illness or injury because of which he is no longer able to work and earn money. Say for example, loss of limbs, loss of eyesight, total paralysis, loss of both legs, loss of both hands. This is called permanent total disablement. So how the compensation will be calculated? Formulas are okay. In case of death, 50% of the wages. In case of permanent total disability, 60% of the wages. This has to be multiplied with the relevant factor. So let us take an example to calculate the compensation. Say in my factory, a workman of 46 years died due to accident during the working hours, and I was paying to him 15,000 rupees per month. This is a practical case. 46 years is the age 15,000 per month is the wage. Relevant factor, if we are picking up from the table, here it is 166.29. In case of 15,000, in case of death, 46 years, the amount of compensation would be 12,47,175. And if we are practically calculating it, the same amount would be there. How same amount would be there? Let's see how same amount would be there. 46 years, 15,000, 50% formula, means 7,500. Relevant factor 166.29. Multiplied with 7,500 into 166.29, the amount is 12,47,175. Same amount. Since this is higher than the 1,20,000, so this amount would be paid to the dependents of the deceased workman who died during the course of employment. So this is the way how the premium is, the compensation is calculated. In the case of permanent disablement, the maximum compensation payable is still higher, that is 20,56,860. Here suppose this person has not died. Here suppose the permanent total disability. Here suppose the permanent total disability. What would be the formula? 15,000 into 60 upon 100. Same relevant factor 166.29. So the compensation would increase by 10%. Let's see in the table. $46, not death, permanent total disability. 46, 166.29, compensation would be 14,96,610. Nobody can change it. This is as per law. And not even a single amount can be deducted on account of compulsory excess or salvage value or any other thing. Same amount has to be paid. Let's take one more example. A shopkeeper is there who has a labor for his shop for cleaning, opening, closing, and all other general work. The age of the person is 30 years and he is paying only 3,000 rupees per month. So during the working hours, suppose the fan has fallen on his head and he suddenly died at the spot. Compensation has to be paid to his family members. How it would be calculated? 3,000 is only the monthly wages. So 50% of 3,000 is only 1,500. As per the age, he is 30 years. The relevant factor at the age of 30 years is 207.98. So the 1,500 is multiplied with the 207.98. The compensation payable would be 3,11,970 only. Since this is more than 1,20,000, so this amount would be paid to the dependents of the deceased worker. Suppose he is not died, but he has lost his both the eyesights permanently. Formula applicable is 60 upon 100 into relevant factor. So 60% of 3,000 is 1,800. 1,800 multiplied with 207.98, whatever amount comes, that is payable. Simple thing. So that is the way how the compensation is calculated in case of death or disability of the workers. Here an important question is, where death is there, formula is 50% of the monthly wages, minimum compensation limit is 1,20,000, maximum is 17,40,000. If the permanent total disability is there, 60% is the formula, minimum compensation payable is 1,40,000, maximum is 20,56,860. If the permanent partial disability is there, the partial disability has to be certified by the doctor and that percentage would be paid to the workman. These are the cases of permanent total disability. Under these circumstances, 100% compensation is payable. If the person has lost both the legs, both the hands, both the eyes, or one hand, one eye, one limb, one eye, 100% compensation would be paid because he has permanently lost. That cannot be recovered. But permanent partial disablement means, suppose one leg is lost, one hand is lost, one eye is lost, or even the part of it is lost. That means workman is not permanently disabled for full capacity. There could be back injury, hearing loss, loss of speech. So that would be decided by the doctor. How much is the percentage of partial disability? That partial disability percentage would be payable. It could be 90%, it could be 9% only. It could be 2% only, it could be 5% only. Whatever is the percentage decided by the doctor. In the medical report, that compensation would be paid. That percentage would be applicable here. This compensation is not directly paid to the workman, this is paid through the Commissioner of the Workmen Compensation Code or Commissioner of Employees Compensation Code. Because this is the authority who will give the sufficient proof of discharge of the employer's liability. There could be temporary disablement also. In case of temporary disablement, if the condition is that the employee can recover after the medical treatment. So as a result of such injury, temporarily incapable of doing the work which he was doing. In such a case, what will happen? Only 25% of the monthly wages of the employee is payable. Then comes rating. This is the calculator provided to all branches. Here if you are filling the content, the premium will be calculated automatically. Policy does not cover certain things. Say for example, any injury which does not result in fatality or partial disablement for a period exceeding 3 days is not paid. Means for one day it is the injury, simple injury, this is not covered. First 3 days of disablement where the total disablement is less than 28 days. More than 28 there is no deduction. But if it is less than 28 days, 3 days deduction is there. Only this is deductible and nothing. But the liability cannot be entertained if the willful disobedience is there, willful removal of disregard is there, and if the workman is under the influence of liquor and drugs. If the workman is drunk, he is bound to fall somewhere. Accident has to happen. If he is assigned some other work but he is doing different work, this is willful disobedience. He is given full safety equipments like hat, gloves, long foods, torch. Persons working in the mines or hazardous areas, they are provided with the safety methods. If they are denying and not using, in that case, this is not the responsibility of the employer to pay the compensation. So basically, these 3 things are exclusions of the policy: drink or drugs, disobedience willfully to orders and rules, and disregard willfully of any safety devices. In case of natural death means if any employee is working in the office or factory or mines or at any place and he suddenly died, this is not the responsibility of the employer. If it is aggravated by any manner by the employer, then only the company is responsible. Otherwise, natural death is not covered. There could be one interesting thing. This question is always comes. If the compensation is due to pay because the workman has suffered injury, but he has got the PA claim, still the WC policy has to pay the compensation. Because the same employer has a GPA and GPA amount is paid to him. Is he still entitled for the compensation of the employee compensation insurance? The answer is yes. Because PA is a different policy, this is not the statutory liability. The method of calculating the premium of personal accident policy is different. The method of paying the compensation under the PA policy is different. PA policy has the wider coverage like 24/7, anywhere, around the world, all the times, the risk is covered. This is not so in the WC policy. So even the claim received under the GPA policy or PA policy, still the compensation as per section 17 of the Employees Compensation Act is payable to the worker or to his family. So whenever you are working on any proposal, mind one thing, that we do not accept the proposals on the workers who are engaged in the heights, underground areas, prone to landslide and flooding, areas surrounded with the water, metal forges and foundries, blasting and tunneling, chemical industries, and where this employee state insurance scheme is already applicable. There is no need to give the WC policy. So this is all about the WC policy. Now you can ask any questions. Whatever questions you had in your mind, you can ask. Any questions?